Have you ever wondered who truly owns the brilliant reports, innovative designs, or proprietary data you create using a cloud-based software tool? It is a fundamental question at the heart of many business operations today, shaping how we protect our most valuable digital assets. In most software-as-a-service contracts, intellectual property rights are handled by clearly separating ownership. You, the customer, typically retain ownership of your data and content that you input or create using the service. Meanwhile, the SaaS provider maintains ownership of their underlying software, code, and platform. This distinction is fundamental because it defines the core relationship. The SaaS vendor is providing you with a license to use their product, not ownership of the product itself. Think of it like renting a car. You own the journey and the memories you make, but not the car itself. Your data, which includes your text documents, images, financial records, or customer information, remains your intellectual property. The contract ensures that the vendor can process this data to provide the service, but not claim ownership or use it for purposes outside the agreement, unless explicitly stated for aggregated or anonymized data analysis. This protection is often reinforced by strict confidentiality and data processing clauses within the agreement. The vendor needs to protect their proprietary software development, which is their core business asset. They license it to you, granting you specific rights to access and use it, but they always hold the patents, copyrights, and trade secrets related to the software itself. To navigate this effectively, carefully review the intellectual property, data ownership, and confidentiality clauses in your SaaS contracts. Look for clear language that confirms your ownership of your customer data intellectual property and specifies the vendor's limited rights to access or use it. Understand the difference between your content and the vendor's software intellectual property. Pay close attention to clauses related to service improvements, which sometimes grant the vendor rights to use anonymized data for product enhancement. A key element to understand is the concept of an indemnity clause, particularly intellectual property indemnity. This means the SaaS vendor agrees to protect you from legal claims if their software infringes on a third party's intellectual property. Conversely, you as the customer might indemnify the vendor if your data infringes on someone else's rights. Another critical provision to look for, though less common, is source code escrow, which can provide access to the vendor's software source code under specific conditions, protecting your continuity if the vendor faces bankruptcy or other severe issues. Ultimately, a well-structured SaaS contract ensures that while you benefit from powerful software tools, your own intellectual creations remains yours. By proactively examining the intellectual property and data clauses, you protect your business interests, maintain control over your valuable data, and ensure a clear, secure digital partnership with your SaaS providers.
Like what you learned? Subscribe and stay sharp with the SaaS Pros Breakdown.